Hi, everybody, and happy noon Eastern Time. We will get started in just a few minutes. Welcome back to the iBCI-CC Fundamentals webinar series. My name is Lee Hochberg, one of the organizers. I'm here with Jen French, who you can't tell, but she's right there. And Jessica Kellerman, who, of course, is on the screen. For those who are joining for the first time, the Implantable Brain-Computer Interface Collaborative Community, which is somewhat conveniently named the iBCI-CC, is composed of clinicians and researchers and regulatory experts and patient advocates and people with lived experience of neurologic injury or disease, and care partners, industry leaders, and others who share commitment to innovation and wide access to implantable BCIs. The iBCI-CC is also proudly the first FDA-participating collaborative community in the clinical neurosciences. We're now more than 400 members strong, but we want more. So if you have colleagues who can contribute to our collaborative community, please ask them to join. And for your convenience, we'll provide a link in the chat. Our iBCI Fundamentals webinar series was created to kind of foster a common understanding of key challenges and opportunities in the implantable BCI field. Our goal is to provide a 101 level introduction to complex topics in, among other things, device regulation and reimbursement, and key for today, neural data privacy, hoping that we can build a shared knowledge base that'll facilitate our work group discussions and consensus. Today's webinar is for iBCI-CC members, but it will be recorded and maybe edited if needed, and then posted publicly on our website to ensure that the insights shared here are accessible to a wider audience. Today's fundamentals session is titled Neural Data and HIPAA. What do we know? What can we share? So for many, when we think about iBCIs and the future benefits that we hope that they'll bring, that hope is pinned largely on the neural data that are recorded and transmitted and decoded and stored toward restoring communication and mobility. But fundamental questions remain regarding neural data and security, the answers to which will reflect our ethics as a field and as a society, and how we strive to balance a variety of interests. Who needs access to the data? When can they be shared? How do we balance data security with continued innovation? If the data being used by the original iBCI user are actually being used to generate a public social media post, why secure them at all? Or is there something else that's sensitive in those same data that warrant additional care in their handling? And to what extent do our current laws inform our approach? In today's webinar, we'll provide a 101 level insight to HIPAA and to how current federal law addresses the handling of physiologic data in medical devices, including neural data. We'll also touch on how state laws and the policy landscape are actively evolving. And in this important and recently hot topic, our hope is to give us all, including me, some basics, informing our collaborative community's deeper discussions and efforts to reach consensus. And if you've never used the phrase covered entity before, I suspect you'll use it before dinner. So we're really thrilled today to be joined by today's speaker, who brings a wealth of knowledge about privacy laws and cybersecurity practices in medical device regulation. Marcy Wilder is a partner at Hogan Lovells. Prior to her current position, she served as the Deputy General Counsel of the U.S. Department of Health and Human Services, where she led the legal team in drafting the Health Insurance Portability and Accountability Act, that is HIPAA, privacy and security regulations. She holds a JD from Stanford, was a women's law and public policy fellow at Georgetown. Marcy was named to the National Law Journal's Regulatory and Compliance Trailblazers and is consistently ranked as a top-tier privacy lawyer by Chambers USA and the Legal 500. I will add that I've learned a lot from Marcy over the past several months, and I'm really excited that she's here. Just a couple notes, because the iBCI-CC operates in a pre-competitive space, proprietary information about specific companies are not a topic of discussion. Our goal today is simply to educate broadly, avoiding any focus about the regulatory or reimbursement path of any specific companies. We will leave time at the end for Q&A, so feel free to add your questions to that Zoom Q&A box throughout the session. And with that, Marcy, it is really an honor to turn this over to you.
Thank you so much for that great introduction. I am very happy to be here today with you talking about this important topic. I've spent much of my career working with health technology companies and thinking about how we protect personal health information writ large. As brain-computer interfaces evolve and AI capabilities improve, the privacy questions get more fascinating and more challenging. And the technology that you are working with raises new legal, ethical, and human questions that the law really is just starting to grapple with. Those questions are not questions we will be answering today. Today, we are 101 level about the HIPAA fundamentals. I think will be helpful in grounding and helping to advance your thinking, our thinking about these issues, given the privacy laws we have today. So, next slide. So, today's topics is neural data health data, personal data, or something else? Do HIPAA and state privacy laws even apply to neural data? And how do the privacy laws affect the neurotechnology landscape? The stakeholders you see that we're going to talk about today are healthcare providers, device manufacturers, researchers, and there's a whole nother webinar we can do from a patient perspective and the rights that patients have. But today, we're going to do HIPAA building blocks. Next slide. So in terms of the US legal frameworks, neural data is typically defined in the law as information generated by measurement of the activity of an individual's central or peripheral nervous system. That covers a lot of kinds of data. And the two things we'll be talking about, and primarily it will be in the US, for the US, it will be HIPAA and the state privacy laws. And I will note that California, Colorado, Connecticut, and Montana have already amended their laws to include neural data. Whether this is for better or worse, we really don't know yet. That goes to the is it different, is it the same question. But the point here is that in the US, although I don't think we're going to see much at the federal level in the next few years, I think the states will be our lab here, and HIPAA will be our framework for federal privacy regulation. Next slide. Okay. This is big overview HIPAA, right? It's a privacy rule, it's a breach notification rule, it's a security rule, it's an enforcement rule. So there are lots of regulations that make up what we call the HIPAA regulations. We're going to focus today on the privacy rule. It is most relevant to the data sharing questions you want to address, but I want you to know that the others are there and play into the privacy rule. Next slide. The two key concepts we're going to talk about, covered entities and business associates. Why do I start here? HIPAA is a strange and lovely regulation based on a statute that really wasn't designed to address privacy. And for that reason, there are really only three types of entities covered by that statute. And they are healthcare providers, health plans, and healthcare clearinghouses. We're not going to talk about plans and clearinghouses. We're going to talk about the providers that are covered. Now, it's also true these days that business associates are covered. That's because of an amendment to the original statute. And what is a business associate? It is a vendor, essentially, or a partner of a covered entity, oftentimes a healthcare provider for implantables, that creates, receives, maintains, or transmits PHI, that's protected health information, for or on behalf of a covered entity. So we have covered entities, typically in this context, healthcare providers who are treating, that have, call it neural data. And there are business associates who are part of this process and part of the data flow. And we're going to get into that later. But those are two key concepts, and different rules apply. So covered entities can do some things with the data. Business associates can do other things with the data, not the same. Next slide. What does it mean to be a business associate? I take it we all know what healthcare providers are. Not everybody knows what business associates are. So, for example, when we talk about vendors that get access or store or process protected health information, HIPAA covered patient data, those are cloud providers and data storage companies, BCI device manufacturers, the AI analytics providers that are processing neural data to generate medical reports or actions, software developers building apps to display neural data to patients, right? They come in lots of flavors. And so you have to be clear in your contracts and in your compliance approach where you sit in the chain. And these are some examples. And I'm going to focus on data storage companies or cloud providers for a moment because some of those cloud providers are literally just storing the data. They're not doing anything else. They're not processing. Storage alone will make them a business associate for these purposes if they're acting on behalf of a covered entity. So it covers a broad swath. Next slide. So how does HIPAA apply to business associates? These business associates, these vendors, these partners, although not HIPAA covered entities, not subject to the entire privacy rule, are subject to the security rule, the breach notification rule, some parts of the HIPAA privacy rule, and their agreements. So where business associate agreements appear in your relationships, you're going to want to pay a lot of attention to what they say, what rights they give or abilities they give to the business associate to use or process the data, and what rights they don't provide. Why will we pay close attention to that? Because business associates can use that patient data only as permitted or required by the applicable business associate agreement. The data does not belong to the business associate. Next slide. So here are some principles, right? Healthcare providers are regulated, they have patient data, they're typically medical records, not so much the business associate. The business associate does not own the PHI, it is not yours. And as between the business associate and the covered entity, the PHI belongs to the covered entity customer to begin with. That covered entity can authorize uses and disclosures of PHI to a point, but if they don't, other uses are generally prohibited. The minimum necessary concept applies. You've seen that in other contexts, which is they can disclose only the minimum necessary to a business associate. Business associate can use only the minimum necessary to accomplish the permitted tasks. And secondary uses, talk a little bit about that later, are limited. Next slide. So when we talk about business associates, I want to just touch on a few points. One, the uses are limited, as I just said. Two, you are covered by the regulation, which means you may need to provide access to your books and records to allow HHS to audit the covered entity's compliance with HIPAA. And these contracts can include underlying optional data rights provisions, the ability to de-identify or aggregate the data. I see the question about anonymized data, which I'm going to get to almost right away. Next slide. There are also termination-related obligations. You've got the covered entity needs to be able to terminate that relationship. The business associate has to return or destroy all the PHI upon termination if that's possible. And if not, they have to keep it for certain reasons. They're limited in their uses. Next slide. Subcontractors, the only thing I'm going to say about that is if you are a business associate and you are subcontracting some of that processing or other types of functions, you've got to flow down those business associate obligations to your subcontractors. So HIPAA is going to follow the data from the healthcare provider to the partners and down to their subcontractors. You cannot break the chain. Next slide. De-identification. I'm going to take a step back and talk about the big picture of individually identifiable health information. It covers a lot of ground. It relates to past, present, or future physical or mental health or condition of the provision of health care to, the past, present, future payment for the provision of health care to an individual, right? So anything really related to past or future health of an individual is considered individually identifiable health information. Now, an easy example is the fitness data that's flooding the market today. People have wearables, they've got watches, they've got rings, they've got monitors. All of that information that's being generated by people, by consumers, by patients is health information if it's identifiable. And then that little bubble, and that's regulated by state law, regulated by some federal laws, the FTC. Within that bubble is HIPAA covered protected health information, right? So it's just a subset. So we think about a large group of laws we're not talking about today that apply to individually identifiable health information. And then HIPAA is targeting essentially data that is generated in a patient or clinical care context. It's a big oversimplification, but it's an easy way to think about it. You will notice on the slide, in the bottom right, there's a little circle that says de-identified information. It is not in the big circle of individually identifiable health information. If it is de-identified, it falls outside of the circle and it is no longer regulated by privacy laws. One of the challenges is de-identified information has a very specific meaning in the context of HIPAA and the state laws. And so, for years, for decades, researchers were used to thinking about de-identified information in one way, coded data, call it, and that's just not legally de-identified, generally speaking, under HIPAA and some of the new state laws. So let's talk about that. Next slide. So creating de-identified data. For HIPAA purposes, de-identified data is not PHI, is not protected health information, but confidentiality and state law restrictions may still apply. So it's different. Next slide. Under the HIPAA regulations, where we're starting with patient identifiable information, there are only two ways to get it out of the big circle. Only two. There are two methods. One is the expert determination method, and the other is a safe harbor. With the expert determination method, essentially there are rules about certain qualifications, but you can have an expert certify a given data set, sometimes even a process, de-identification process, that certifies that the likelihood of re-identification is very small using prescribed statistical methods. So there is the expert determination method of de-identification. There is also a safe harbor, supposed to be easier, a quick route. The challenge of the safe harbor is that you must remove 18 types of identifiers of the individual, relatives, employers, household members, and there can be no actual knowledge that the residual information can identify an individual. There are some complex issues regarding codes and re-identification codes, but that's for the 201 course, not the 101. So we're not going to get into that today. These are the two methods. Next slide. I put up this slide with the 18 types of de-identifiers that need to be removed in order to be safe harbor de-identified under HIPAA, because you will look at this and many of them you will not care about, but some of them you will. Typically, dates, sometimes zip codes, sometimes device ID numbers. So the data needs to be pretty stripped down and sometimes is not useful once you have removed all these identifiers for the task at hand, oftentimes research. And so you've got to choose or figure out if safe harbor de-identified information is sufficient or if you need to go the expert de-identification route. We can also talk about some of the more advanced methodologies for de-identification or the generation of synthetic data, but that's for 201. The basic legal premise here is there are only two methods under HIPAA to de-identify. And if you don't use one of these two methods, you are not outside of the HIPAA circle. Next slide. States are adding additional requirements on top of the HIPAA requirements. They're not typically onerous, but you do need to pay attention. Typically, if you look at the state laws, California led the way on this. They're going to require not only that you follow the sort of you start with the HIPAA standard, but that there be in place technical safeguards that prohibit re-identification, business processes that specifically prohibit re-identification, probably a policy, business processes to prevent the inadvertent release of de-identified information, and representations that there will be no attempt to re-identify the information. So these are promises essentially that need to be made or policies that need to be in place to, again, ensure that that data stays inside or stays outside of the HIPAA regulated or the state privacy law regulated regulations over de-identified data even. There are exceptions. There are certain exceptions for research and other kinds of things. But the basic premise here is you've got HIPAA, you've got these state law add-ons, and if you're aware of those, you've got a good start on how to ensure that your data set is and remains de-identified. Next slide. Before I talk about research, I think there were two questions. Do we want to hold the questions to the end?
Yeah,
okay.
I think so.
Great. I'm not going to talk a lot about HIPAA and research because we have lots of people who are familiar with the research rules. And all I'm going to say is that HIPAA was not, in fact, designed to govern research. It is sort of based on, took a lot from the common rule. And it does have some sort of add-on requirements with regard to protected health information. So, for example, in addition to you'll see their add-ons. In addition to a consent, you would need an individual's written authorization. You have an IRB approval or a privacy board approval. You can get an IRB waiver of the consent requirements. There are provisions around sort of what I'll call data use agreements, partially de-identified data that can be useful. And there are exceptions for de-identified information. So it's really not the primary regulator for research, but there are a couple of provisions you need to pay attention to, particularly where you have identifiable, consented, or partially de-identified data. Next slide. I want to talk for a moment about the sale of protected health information. And while in this context, lots of people do not intend to sell patient information. People hear that and they're like, we would never sell patient information. Why would we want to do that? We are privacy protective. Sale of protected health information can mean a lot of things. And it's very bad under the rules because it can result in civil or criminal penalties. So I like to flag it so that people are aware that there is this prohibition and that a sale is defined as a disclosure where an entity directly or indirectly receives remuneration from or on behalf of the recipient of the PHI in exchange for the PHI. And it is prohibited unless an individual actually authorizes the sale specifically. It includes the exchange of non-financial benefits. And de-identified data is exempt, but I want to flag that the restrictions apply to selling analyses that may be de-identified, but that were based on identifiable data. So you want to be careful about using identifiable data in what turn out to be unlawful ways and then sort of selling or providing the de-identified results. That is a trap we have seen some of the enforcement authorities go over. They look at a lot of these data deals. The state attorneys general in particular have been interested in this. They are looking at some of the big tech companies and the cloud providers, looking for sweetheart deals that they're going to characterize as sales. So just as you establish the relationships and the partnerships, just be aware of this restriction and that it is an area of focus for the state regulators and a little bit on the FTC. HHS hasn't really looked into this yet, but again, we have multiple regulators you want to be thinking about. Next slide. So I want to talk for a moment about HIPAA and neural data specifically and where some of the key stakeholders fall in the chain that I described. So we start with healthcare providers, right? Typically treating a patient. And the healthcare providers can use or disclose identifiable health information for treatment, to get paid, and for term of art healthcare operations purposes, right? Sort of to the extent it's necessary to run the practice, certain kinds of quality benchmarks and things like that, they can use it. They can use and disclose de-identified data for any lawful purpose. Importantly, they can de-identify the data when they want, when they feel like it. There are really no restrictions at all on a healthcare provider's or covered healthcare provider's ability to de-identify data. They can de-identify it, they can sell it, they're allowed. They can also give permission for others, for a business associate to de-identify the data. So they can outsource that function under certain circumstances and then make it available more broadly in the industry. I'm sure you've all, pharma is a big purchaser of de-identified data for lots of reasons, and it's lawful. The device manufacturers are a complicated question. I'm gonna walk through an example on the next slide, but not yet. The extent of the use or disclosure of that patient health information depends on whether they are a covered entity or a business associate. It's really what rules apply, and it varies depending on the context. It's not an easy answer, but it's an important question that I spend a fair amount of time working through as I work on these arrangements. Business associates. Business associates can use and disclose that that identifiable neural data for limited purposes. And for that, I mean, you're a business associate. That means you are acting on behalf of a covered entity. There's usually an agreement or an arrangement about what you are doing on behalf of the covered entity with that data. Could be you are the provider of the algorithm that is generating certain types of information that make a machine work, that help the patient move an arm, or recover speech function. And that's your job. You are supposed to be using that information for that purpose. Now, the question often comes up, yes, and can I de-identify it and then use it for other purposes? And the answer to that will rest in the business associate agreement. If the business associate agreement gives you permission to de-identify the data, you can do that. If the agreement is silent, you may not. So you need, as a business associate, permission. Once, as a business associate, you de-identify the information, not covered anymore by the agreement, not covered anymore by HIPAA, and you can use that for any lawful purpose, and there are lots of them, including selling it. What about researchers? Researchers can use and disclose identifiable neural data subject to, for in HIPAA terms, an IRB waiver or authorization. They can use or disclose limited data sets that's partially de-identified data subject to the terms of that contract. And they can use and disclose de-identified data for any lawful purpose. So you can see why that statistical certification of de-identified data can be very important. One more thing I want to say about that, though, is there are lots of parts of this ecosystem that run on statistical certifications. And one of the challenges there is that in that certification, there are usually certain types of restrictions, for example, on combining the data with other data sets. And so you have to be mindful of what are the limitations of that statistically de-identified data so that you stay within the bounds of what is certified. At another conversation, we can talk about the group of people that believe that certain kinds of neural data can never be de-identified, that it is like a fingerprint. I am aware of those conversations. I've participated in those conversations. What I would say is today, the state of the law in the US, like genetic data, is that it can be de-identified. Whether or not that's true in fact is a different question, just as it is with genetic data, but it can be de-identified today. And I think that will continue to be the case, maybe with some parameters around it. Next slide. So who can access and use and disclose depends on how the relationships are structured and the HIPAA pathways available, right? And when I say HIPAA pathways, those are the things we've just talked about, right? You can have a business, you can be a provider, you have lots of pathways. You can use it for treatment, you can use it for payment, you can use it for healthcare operations. You can, as a healthcare provider, get patient authorizations for research, for other kinds of uses. There are a lot of ways that healthcare providers and a lot of flexibility that healthcare providers have for the data that's generated in the context of treating patients. For business associates, there are fewer pathways, but pathways nonetheless. Getting contractual permissions, acting on behalf of the covered entity, de-identification, data use agreements, and research are all pathways to data use. And in all of this, the contract terms are key, the consent terms are key. So it's not that these avenues are foreclosed, they're open. And once you understand what you're trying to do, it's oftentimes not complicated to get there. It sounds complicated sometimes, but there are pathways here. The law is meant to enable advances in research. It's meant to enable treatment. It's meant to stop certain kinds of marketing, certain kinds of uses of health data that endanger patients. It's meant to stop data breaches or prevent data breaches. But there is an ecosystem here that the law is trying to support and enable and offers tools to do that. And so the mindset going in as you do your work and you establish these partnerships is let's just figure out the pathway, get it on paper, and do our work. Doesn't need to be complicated, except when it is complicated. So, and that's not always. Next slide. Here's an example of when it gets complicated. Just a little preview of how this plays out in some of the more difficult contexts. And when I did the slide, I said, device manufacturers, just an example for discussion, not legal advice. So we're just talking here today. And the question of the device manufacturer, which has come up, it's not a new issue. There are cardiac monitors. There are sort of lots of kinds of patient monitoring. There are established industry practices. This, implantable brain-computer interfaces will be another, or is another. So the manufacturers are sometimes covered entity. Sometimes they're business associates. Sometimes they operate with patient authorizations. It's not on this slide. When is a manufacturer a covered entity? It does happen. So, for example, in certain kinds of monitoring, the manufacturer will bill a health plan for the technical component of a service, while the healthcare provider bills for the professional component of the service. If you're at the point as a manufacturer where you are billing health plans essentially for part of the treatment that's provided for an individual, that can and will tip you into being a HIPAA covered entity, which for many years had big disadvantages. And so they tried to avoid that. Lately, in part because of the types of data uses you can make, and in part because of some of the exemptions from state laws, manufacturers are looking at this differently and thinking about maybe it's better to be a HIPAA covered entity. And once you are, you can disclose identifiable neural data for treatment, payment, and healthcare operations purposes. And that's important. Healthcare operations purposes can be a difficult question because the line between healthcare operations, call that quality improvement, is permissible. Product development is not a healthcare operation. That would be prohibited. And research is not a healthcare operation. That has to follow the research rules. So we just got to sort it out and understand the pathway. But it can open doors, being a covered entity can open doors to data use that were previously closed. And as a covered entity, as I said before, you can de-identify the data. You don't need permission, it's yours. So there are other contexts, and I would say most in this ecosystem the way it exists today, the manufacturer will be a business associate, meaning they're really doing the services on behalf of the healthcare provider. It's part of providing their treatment. You're supporting them in their treatment. So where they're not billing health plans directly, there it's much more limiting. You can use and disclose the neural data for the limited purposes provided in that contract, which necessarily need to be limited to supporting the work of the healthcare provider or for these purposes, controller of that data. And you can de-identify it if it's permitted, if those covered entities have given you permission, but you cannot de-identify it if you do not have permission. And depending on the context, that permission can be hard to get because de-identified data has a lot of value. There are deals that some of the larger health systems are working out with other kinds of vendors to try and extract value. So depending on context, you can or cannot get permission for de-identification. And I flag this because it's at the, sort of like 301 level to try and sort out in some of the more complicated fact patterns who sits where and what's in the interest of each of these particular players. And that's going to depend on what the goal is. What is the goal? Are we trying to share data? Are we trying to hoard data? Are we trying to monetize data? Right? Lots of different goals. Or are we just trying to play collaboratively, be collaborative, make as much data available for research so that we can actually move this field forward quickly and leverage the technical developments that are enabling and driving the tremendous growth in this sector right now. Next slide. I want to talk for a moment about enforcement. Who enforces HIPAA? The primary enforcer is the U.S. Department of Health and Human Services Office for Civil Rights. The way that these, and they are, they have priorities. They publish them every year. They focus a lot on security. They focus a lot on an individual's right to access their data. And they focus a lot on data breaches. And where there is an event or a data breach that involves more than 500 people, individuals, they're actually required to open an investigation. Those investigations typically, if they're not closed with no action, typically will end in some kind of a monetary penalty and a corrective action plan, which requires those found in violation or those entering into this thought to have violated the rules to take a set of actions, usually over they're usually monitored for 3 years. And they can be, they're oftentimes focused on security, and they can be expensive and restrictive. So better to avoid that if you can. There are criminal penalties that the Department of Justice enforces. Those are very rarely invoked, but they are there. The Justice Department has said that if you are not covered by HIPAA, that they will pursue like aiding and abetting theories to get to the people who are inducing the use of PHI for commercial purposes in violation of the law. They care a lot about that. But again, it's rare. I think that if we litigated these, which we typically don't, you would need some kind of intent, right, to actually violate the law, and that's not typically what we see, but they're there, and so we want to be careful around that. The state attorneys general also have HIPAA enforcement authority. I think that they're happy to go after that. They've had a number of actions, some related to data breaches, some related to data deals between tech companies and healthcare providers. And I think it's less of a risk right now with the state of your industry, in part because they're typically bootstrapped to consumer claims and consumer protection statutes. The people that we're talking about here don't typically have maybe a relationship with the patient, or they're not making representations directly to the patient. So I think it would be harder for them to leverage those claims. But where you are interacting with patients, I think this comes into play. And you have to think about the FTC, which I haven't talked about today, to that next time, and consumer protection claims. And the state AGs have some civil monetary penalty authority and also injunctive relief. So it's HHS, DOJ, state AGs on HIPAA, it's FTC on consumer protection claims, and it's the states for their state privacy laws. Next slide. We've arrived. Q&A.
Amazing. Marcy, thank you so much. I think there's an occasional experience of kind of going to a lecture early on in the semester, and you hear the first lecture by the professor, and then you decide that that's now your major. You're going to take 201 and 301 and 1227 or whatever the rest of the courses are because it's so captivating, and that's what you just presented. So thank you. There are a ton of questions. I'm going to look over my laptop for just a second. I think Jen is going to handle the Q&A. Is that true? Yes, you are. You're looking and nodding. That's good. If I can, and I'm going to get permission from Jen too, I'd like to pose one kind of toy example just to get us started based on some of the Q&A and questions. Marcy, if you're willing to engage me for just a moment.
Sure.
Because I think it'll be helpful, at least for me and for others. Let's just imagine that there is an implanted brain-computer interface. That is a device. It is purchased by a hospital. It is placed in the brain of the user. That user returns home, and the user is using that device and simply uses the device for a communication purpose. And the phrase that they've uttered using the implanted BCI is, "Today is a sunny day." So there are neural data that were recorded that were related to that intended sentence of "today is a sunny day." And those data are then available to any number of people or entities. But we can come back to that if needed. Are the neural data related to the phrase "today is a sunny day" PHI?
So the question I would ask, I need to know more about what do I assume about whether that function is part of treatment? Have we taken it out of a treatment context? It's not treatment now. Now it's a device that the individual has and has agreed to have and is using. So if we take it outside of the treatment context, the question I have, the answer to your question, by the way, is not necessarily. And if the goal is to ensure that it isn't, what I would want to do, and I think that there are pathways to that, right? But what we have to do is look at that set of relationships, who has access to that brain data, that raw data, and why, what is the function, and then we can figure out how to structure the set of relationships in a way that moves whatever the project is forward. Some of that may have to do with what the patient agrees to up front and what they don't, right? That may be the answer to this question if we make it about a relationship between the parties and the patient, because the patient does have control over that data. They can make it available for various purposes. And one of the things we could look at for that, and fitness data is a great example. Some fitness data, for example, is generated in a clinical context, but also exists outside a clinical context. And once that patient has control, they can make it available for lots of purposes. So we probably look at a pathway like that.
Thank you. I have 12 follow-ups, but I will resist and I will hand over to Jen across the table from me.
Marcy, again, thank you so much for an incredible talk. I learned a lot. I'm writing a ton of notes, and yes, there will be definitely follow-ons. And I'm sure we'll be drawing from your expertise further as we develop implantable BCIs here in the future. But we have questions. So we have more and more questions for you. So let's hit up for some of the early questions that came on in terms of, this one's from Lynn Brailmeyer. So hi, Lynn. He asks, can business associates simply avoid HIPAA encumbrances by just adding a waiver into their agreement or into their, terms and conditions agreements that they might have? Is there a pathways further on where they might just be able to avoid HIPAA?
No. Next question. No. Well,
Okay, that's great. We like questions with simple answers, right?
No, I say no because if you are a business associate, meaning if you are receiving that data in order to provide a service or a function on behalf of the healthcare provider in this context, if that's the arrangement, you are a business associate, whether you have a business associate contract or not. HHS will take the position, you are a business associate, you are subject to the rules. You cannot waive your way out of it because the agency takes the position the law is the law. It applies where it applies as a matter of law. Now, if that what we would look for, if that's the goal, is are there pathways to structure the relationship in a way that does not trigger HIPAA or business associate obligations? That would be the conversation. But if you are, there's not a way out of it.
Right. So it's not a clear no, but it could be, it's how we structure those relationships, which I think is what you've been saying quite a bit is the structure on to follow the data, from my understanding. So speaking of data, the next question I think was in the context of those 18 types of data, that for de-identification. And this question is from Jason Temper. It's about what about data elements that are used for historical timestamp series analysis? So is that covered under some of those 18 types of data?
It depends on what the timestamp is telling you. How detailed is the timestamp, for example? It's a time and a day, and it, it's sort of. I think that it depends on the timestamp, and the answer is it depends. But timestamps can be PHI depending on what's included in them.
Okay. Good to know. Next question comes from Nivis Comer. And his question was about, the exemptions that you had early in the beginning of your talk. So his question is who is qualified to be an expert in the expert determination method?
So there are specific requirements or conditions that need to be met to qualify as an expert. They are not particularly specific. And so there are not many of them. Let me put it that way. So some of the companies, there are some individuals out there, typically affiliated with universities, that serve as statistical certification experts. There are businesses that do it, Datavant and others. And there are, there are a bunch of companies, I shouldn't have mentioned them. That came to mind. So there are businesses that do it. There are individuals and academics that do it. There are companies and institutions that have internal people who sort of declare themselves experts and issue these certifications. The question from a legal perspective, so any certification, one of the requirements is that it lays out at the beginning, here are the qualifications of this expert, and here are the methods used. So to cover a lot of ground, the question for the people relying on the expert certification is it good enough? Is it credible? Will it serve as a shield legally if, in fact, I go with this de-identified data, I publish it, and it is, in fact, re-identified? My legal defense is going to be, I have this statistical certification, I followed it. So it's a little bit gray, right? How good is good enough? But, sort of we typically say has to be credible, has to meet these regulatory requirements, but there really is not clear guidance as to what's good enough and what's not. You want to use a credible one is what I would say.
Thanks, Marcy. There's a couple of questions. I'm going to try to combine them on similar note, is in regard to the re-identification of data. And we're seeing this pop up related to AI algorithms. And so the question really lies into, how about the ability to re-identify PHI, whether it's cross-referenced with publicly available information or whether it's cross-referenced using AI tools. Could you talk a little bit about that, the possibility of re-identification of data, and how does the law handle that, as well as if that re-identification data is sold, without consent?
Yeah, huge issue, right? Huge issue. And one of the key distinctions I will draw is de-identified data is not anonymized data, right? Anonymized data means it's not going to be re-identified. It cannot be re-identified by anybody anywhere. But that's not the legal standard. The legal standard is it needs to be de-identified, which means, sort of in crude terms, the likelihood is small that it will be re-identified. And the challenge of that AI is presenting right now, and there's lots of people working on this technical problem, is that because of the things that AI is good at, it absolutely increases the risk that information will be re-identified. And there are several challenges with that. The first is a legal challenge, right? That you want to be confident that you are meeting the legal requirements, that you met the standard that's set out and use the tools available. But the second is because this is such a new area, it only takes one instance that is reported in the Wall Street Journal to upend a reputation, an industry, and the like. And so we spend a lot of time looking at the legal risks and the reputational risks and the likelihood that something that is being built and the way that that data is being shared, if we're wrong, we think it's de-identified, but it's not, what kind of harm can that cause, especially to individuals? And so you've got to look at it in the round that way, and in some ways on a case-specific basis, because the issue's hot and not resolved.
Great, thanks. Do we have time for one more question, Jessica?
Uh,
Maybe.
I think we probably should wrap up now. Just
Okay.
to do closing statements and not run over too late and hold everyone hostage.
Exactly. So, but thank you. There are more questions in the chat. We will try our best to be able to answer them. We'll share them with Marcy, and if she's able to, she'll be able to give us some answers on that. So, with that, Marcy, again, thank you so much for enlightening us with your knowledge in this area. There is definitely, with all the questions that are in the chat, there are definitely a follow-on coming on this, or part two, as you had mentioned. So I'm going to hand it over to Jessica for some final statements. Jessica.
Yeah, thank you, Marcy. That was really amazing. And thank you, everyone, for asking really good questions. I just want to quickly announce that our annual meeting is on Friday. So if you're not going to be able to join us in Baltimore, feel free to register online and join us virtually. And we're very excited for that. And also, we are receiving requests already for the 201 lecture on this. So we'll talk to Marcy offline about that.
Fantastic. Really, really delighted to be part of this. So thank you for having me.
Marcy, thank you so much. And for everybody who will be in Baltimore, I look forward to seeing you on Friday, and if not online. Marcy, thanks again.